Hello, welcome to another exciting, very exciting, I'm sure, episode of the wacky adventures of Delete Lawz, specifically DeCastro versus Abrams et al. So, last we were here, let's jump to the docket. We looked at the first response to motion re 105 motion for extension of time to file opposition, and then the first motion to correct. So dockets 107 and 108. And that they were in response to Google had filed a motion asking for more time to file their answer, their responsive pleading. And Judge Burroughs had already granted it. Later that day, Delete Lawz sent in two almost identical motions opposing the already granted extension of time. So I tried, I read the first one. I tried with the second, but by the time I was done with the first paragraph, I felt like my brain would explode from reading such stupidity twice. So I gave up, which was a mistake because apparently, besides a few small changes in bold shouting, I called it, the big change is he removed most of what's highlighted here. Nonetheless, the call was recorded. Thank you to all of you who commented, letting me know that's the main thing I missed, the main change. Because this is the altered, nonetheless, period. So you may ask, what are the consequences of him admitting to potentially wiretapping Google's attorney? Because I believe Massachusetts is a two-party state. Both parties have to agree. I don't know where Delete Lawz was when he recorded this call. So it's dicey. But legally, what's going to happen? Nothing. I mean, Mr. Gorman is not going to go to the Massachusetts police and say, hey, this moron wiretapped me. I want him arrested. Blah, blah, blah. It's not going to happen. But that doesn't mean there aren't consequences. Because, as you may remember, I kind of skip over this on most of the filings just because it's boring. It doesn't matter. But in Massachusetts, local rule 7.1A2 says, hey, you've got to meet and confer before filing a motion. You've got to see if you can work it out. And you see, the court has waived this local rule for the remainder of this action. Well, I don't know that the court has specifically waived it as far as his dealing with Google's attorneys. The court has waived it with Josh and Kate's attorneys. And this is at the bottom of a motion dealing with Google. So the point is that the attorneys aren't going to work with him, period. If he wants something, he's going to have to fight for it. They're not going to give him any courtesy. And furthermore, they are not going to speak with him on the phone going forward. Everything's going to be in email or in open court, because why would they risk having a recording that he can doctor he can edit to make them say anything. So I think that's going to be the big fallout, as minor as that is. I mean, he's impossible to work with anyway, so it was going to happen one way or another. The other change mainly was in the conclusion. Let's see. So he had already asked the court to deny YouTube's motion for an extension of time that had already been granted, but he asked, or in the alternative, to stay any extension of time granted before this response can be filed. Well, the court's not going to do either of those. So those are the main changes. And it got me thinking, which is dangerous. But let's jump back to the docket, and specifically early in the docket. Why? Well, because, as we've said many times, Delete Lawz thinks this is his game. He sets the rules. It's rules for thee, but not for me. Deadlines. What deadlines? Oh, you have a deadline. Let's enforce that. My deadlines. Well, I'm pro se. How could I have possibly known there was a deadline? We've seen it mostly in the Ironton lawsuits, but it happens here. And he makes up deadlines. He decides there's a deadline. It must be enforced. What am I talking about? Well, if you remember, very early, we have docket number 6, a letter/request for extension of time to file a responsive pleading from Catherine Peter, which was granted. The judge construed it as a motion for an extension, granted extension of 30 days. And then Josh filed the same on October 5th, which was granted. 29 days, though, so that they were both due on November 7th. Well, Delete Lawz had decided let's see, because upon the return of summons, it said an answer was due on October 7th, even though Judge Burroughs had said, well, I'm extending it 30 days, so it's November 7th now. On October 7th, well, no, on October 6th, so even before the deadline, Delete Lawz said, hey, clerk, they're in default because I've decided this is the deadline for them to respond. Even though, number one, it was before the deadline anyway, and number two, the judge had moved the deadline by a month anyway, so he was 31 days early applying for a default. And then after applying for the default, he submitted his opposition to the defendant's ex parte motions for extension of time. Doesn't that sound an awful lot like what he just did? Which got me thinking. Let's see. Waiver of service. Docket number 99. Google returned the waiver of service. Answer due the 1st of February. what just passed? The 1st of February. I'm recording this at about 1 a.m. on the 2nd of February. So the main show for today is going to be Kate's opposition to the contempt motion. But frankly, I'm surprised that Delete Lawz didn't file an application to the court to put Google in default. Ask for a default judgment. Because once again, his rules mean even though the judge has already granted an extension of time, by golly, they're in default because I say this is the deadline. So, frankly, I'm surprised that it didn't happen. So, moving on. We have defendant Kate Peters' opposition to plaintiff's second motion for contempt. I have not looked at this at all, other than to open it and its 2 attachments, 2 exhibits. So I'm curious, because remember, this motion for contempt is for Kate's video making fun of his End Torture Cuffs website, which he claims is in alpha testing and not published, and therefore Kate had to access it through nefarious means, and so therefore it's harassment and deserving of contempt, even though it's not password protected, even though it's supposedly in alpha testing. Delete Lawz never does beta testing. He does alpha testing. So I'm curious, both if this mentions passwords and the like, but also if you remember in the video I made a couple videos ago discussing his threats to sue Blue Bacon for trying to serve him with the protective order. And that email where he refers to the motion saying, and Kate is going to have to pay money to respond. And I said, well, number one, I don't think she actually has to respond. But if I were Kate, I would respond, and I would respond with this email. So let's see if that happened. I don't know, but it could. It could have. But before we get started, since I always do this at the end, should have done it at the beginning, I'm getting real close to being monetized. I need 80-something more subscribers. So please like, share, subscribe, do all the fun YouTube-y things. It would be greatly appreciated. With that, let's jump into it. So, defendant Kate Peters' opposition to plaintiff's second motion for contempt. Introduction. Defendant and plaintiff in counterclaim Kate Peter hereby opposes the second motion for contempt of plaintiff and defendant in counterclaim Jose Maria de Castro. Ms. Peter denies the allegations made in Mr. de Castro's second motion for contempt. Further, Ms. Peter requests that the court clarify its orders as to the behaviors parties are not allowed to engage in. Ms. Peter requests this clarification not only to allow her to better comply with the order, but additionally to hopefully prevent future frivolous contempt motions from being filed. Ms. Peter and Mr. de Castro have differing opinions on what constitutes harassing or otherwise inappropriate behavior. Once again, the court has ordered, hey, don't harass each other. It's never said, hey, don't talk about each other, but he ceaselessly talks about her and in a threatening manner even. But every time she talks about him in a video, he runs to the court asking for contempt, which is ridiculous. Relevant factual and procedural background. On October 21st, 2022, the court issued the following order, ECF number 33, which stated in its entirety that the court has reviewed the recent motions filed by each of the parties to this matter, and hereby orders as follows. Plaintiff and defendants are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other or with any individual or entity that may have knowledge pertaining to this matter. Any contact with a represented party should be through their counsel. The parties are further ordered that despite the entry of this order, the hearing scheduled for October 24th, 2022 at 12 p.m. will still take place and all parties or their counsel are expected to attend. On October 24th, 2022, the court further ordered ECF number 43, reminding the parties of the previous orders, stating in part, the parties are reminded of their obligation to comply with the court's order on October 21st, 2022, which forbids all parties from engaging in threatening, harassing, illegal, or otherwise inappropriate behavior with respect to the other parties in this lawsuit. The parties are further advised that failure to adhere to the order may result in, among other possible sanctions, monetary fines. On November 2nd, 2022, the court once again addressed the issue of the parties' conduct surrounding this litigation in ECF number 51, stating in part, to be clear, the parties are not to destroy or otherwise compromise any evidence relevant to this case, like maybe deleting Chili's backup channel. Further, the court strongly recommends that the parties not harass, disparage, or otherwise act unkindly to each other or any potential witness in this matter. It is the suggestion of the court that, going forward, when faced with questions of conduct, all parties to this litigation and their associates hearken back to the lessons they learned in elementary school about getting along with others, proper behavior, and cooperation, and act in accord with those lessons, hopefully without constant recourse to the court. On October 14th, 2022, Mr. DeCastro filed a motion for contempt, ECF number 61, alleging that Ms. Peters' conduct in engaging with her YouTube audience in a live stream about the attempts of Mr. DeCastro to bully and silence critics, wherein Mr. DeCastro joined Ms. Peters' YouTube chat and proceeded to harass Ms. Peter. Ms. Peter filed a cross motion for contempt at ECF 71. On December 1st, 2022, the court denied both motions for contempt. The court stated, in no uncertain terms, both parties have repeatedly engaged in inappropriate behavior towards one another, and the court will not single out one party for punishment where both are at fault. The parties are once again reminded that this is a court and not a kindergarten, and that the court expects the parties to act accordingly. On January 16th, 2023, Mr. DeCastro filed a second motion for contempt, alleging that Ms. Peters' critique of a website, www.endtorturecuffs.com, published by Mr. DeCastro, violated the court's orders and requested that the court hold Ms. Peter in contempt of said orders. Argument. A. Ms. Peter has not violated the court's orders. First, Ms. Peter understood these orders pertain to conduct engaging with one another within the context of the lawsuit. ECF number 33. Plaintiff and defendants are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior, in bold and underlined, when engaging with each other. End quote. Since the onset of the lawsuit, Ms. Peter has not engaged with Mr. DeCastro, nor answered the emails sent directly to her by Mr. DeCastro, or any of his purported associates. See Exhibit 1, emails from Mr. DeCastro, Matt DeCastro. Is that a brother or cousin brother? Or I wonder. The only time Ms. Peter has engaged with Mr. DeCastro is when Mr. DeCastro joins Ms. Peter's live chat while Ms. Peter is live streaming her content to her audience. While dealing with Mr. DeCastro in her live chats, Ms. Peter remembered the admonitions of the court and abided by them. Mr. DeCastro claims that Ms. Peter violated this court's orders by broadcasting a live stream on January 16, 2023, entitled Regarding the End Torture Cuffs Deception Mark Stout Debacle, which contained a live analysis and critique of a website published by Mr. DeCastro and torturecuffs.com. Ms. Peter was reporting on news and giving commentary and opinion on that news through her YouTube channel, which is not engaging with Mr. DeCastro. Mr. DeCastro is not obligated to, nor is he encouraged to watch Ms. Peter's YouTube channel. Mr. DeCastro seems to be under the mistaken belief that any time Ms. Peter reports on his newsworthy antics or engages in the slightest criticism of his, once again, bold and underlined, public website full of misleading and admittedly falsified stories, that due to this court's order, Ms. Peter is not allowed to report on it or to give commentary and opinion on it. Ms. Peter is not under the impression the court intended to place a prior restraint on Ms. Peter's speech. Yeah, because prior restraint is unconstitutional. Indeed, the court said as much in the hearing on Ms. Peter's emergency motion for hearing for status conference and invited the parties to agree not to mention each other on their respective channels. Ms. Peter was willing to stipulate to that deal, and Mr. DeCastro declined. And now he is attempting to use a vaguely written court order to get the benefit of the deal he declined. Once again, he makes the rules. He thinks he's in charge here. Rules for thee, but not for me. I can talk about Kate all I want. She better not talk about me ever. Mr. DeCastro alleges that Ms. Peters' accessing of the site was somehow improper and amounted to committing trade disparagement against plaintiffs yet to be released. Undisclosed technology launch in her YouTube video, ECF number 103. Further alleging that Peter acquired the private URL of a web application product owned by plaintiff DeCastro that is being developed and funded by DeCastro with a third party. The web application product is currently unfinished and undergoing beta testing. I think he meant alpha testing. Although Peter knew that the website was not live, Peter stated, as fact, that the website was complete and disparaged the quality of the site in a video over 2 hours long. Only half an hour of it was dedicated to discussing the website. Most of it was discussing Mark Stout and Long Island audits. This is false, as Ms. Peter accessed the site via the URL www.endtorturecuffs.com and viewed a publicly viewable and published website, indexed and searchable on the Bing search engine. Who the hell uses Bing? See Exhibit 2, Bing search results, which contained no disclaimer nor indication on any page indicating that the site was unfinished nor in beta testing. That's because he alpha tests. Were the site unpublished, as Mr. DeCastro purports in his motion, Ms. Peter would not have been able to access it. Exactly. It would have been behind password protected or just not online, period. Mr. DeCastro further alleges that Peter read several of the placeholder stories on the website and attempted to track down the source of placeholder images and stated as fact that plaintiff was trying to pass these placeholder stories off as real in an attempt at deception with the most bullshit site. Timestamp 318. Peter called plaintiff a liar several times in the video and said that plaintiff himself uploaded the images and typed up the stories in an act of deception to con, grift, and benefit from supporters. Ms. Peter was engaging in First Amendment protected activity, reporting on news and giving commentary and opinion about the news. Mr. DeCastro admits the stories were untrue, and every factual basis on which Ms. Peter grounded her opinion and commentary, which she laid out in painstaking detail in the live stream, are uncontested. It is reasonable for Ms. Peter to have the opinion that Mr. DeCastro is lying when he publishes a website full of stock images and fake stories. Ms. Peter's commentary was not defamation nor harassment, as her opinions aren't facts or defamation, and nothing Ms. Peter did fits the elements of harassment in Massachusetts or federal law. The stories featured on the website and torturecuffs.com appear to be fabricated and implausible, and Mr. DeCastro admits they were fabricated. The images were showed through a Google reverse image search to be taken from other sources, mainly reviews for products intended to treat psoriasis, and news stories relating to the 2023 torture of Belarus blogger Roman Protasevich. By admitting in his motion that the stories were indeed fabricated placeholder stories and the photos placeholder photos taken from outside sources, Ms. Peter could not be engaged in defamation, as truth is a defense. Furthermore, Ms. Peter did not post anything to Mr. DeCastro's website, fake stories or otherwise. Ms. Peter did indeed speculate that Mr. DeCastro's website would attract satirical tales from his many online detractors, but at no time indicated any involvement or even that such a thing had occurred, and Mr. DeCastro has offered no evidence to support his claim. In fact, Mr. DeCastro unpublished the website almost immediately after the live stream. Additionally, when Kate speculated that it would receive satirical tales, she said, "Don't do it." It's on her live stream. She said, "Don't do that." But once again, Delete Lawz, he's the king of conclusory statements, but he doesn't back anything up. Mr. DeCastro's allegations that Ms. Peter literally stalks me on Discord, tracks my business operations and location, and streams any videos I make on back channels are likewise untrue and without merit, and Mr. DeCastro in his complaint offered no evidence or even specific examples of such alleged conduct to support his claim. Indeed, Mr. DeCastro doesn't identify what statute, either Massachusetts, federal, or otherwise, from which he derives his definition of stalk from. Ms. Peter has not stalked Mr. DeCastro under Massachusetts law or federal law, and lacks the ambition or need to research the other 49 states to determine if mentioning someone in a Discord meets a definition of stalking. Mr. DeCastro appears to be just throwing words out at random to see if any accusation will stick. Burn. Ooh. Ms. Peter denies Mr. DeCastro's assertions that Peter knows that my future endeavor website is coming soon, and she obviously knew that the stories were also not real. Nothing on the website stated the stories were placeholders. There was no lorem ipsum text, but actual stories with plots revolving around injuries sustained from handcuffs. I hate the use of unnecessary Latin in legal filings. Every legal writing professor says, write in plain English. Write it so you convey your meaning, but a fifth grader can read it. Lorem ipsum is, in graphical and textual context, refers to filler text that is placed in a document or visual presentation. Lorem ipsum is derived from the Latin dolorem ipsum, roughly translated as pain itself. So basically, lorem ipsum, remember a couple of videos ago when I was discussing the contempt motion, I said, I didn't say it should have been, the website should have been behind a password. It should have been. I said, if I were making a website and I were putting filler stories and filler images to beta test, I'd put pictures of Mickey Mouse. I'd put stories that say, this is a fake story to test if the function works, blah, blah, blah. That would have plainly been beta testing. The lorem ipsum, pain itself. Unfortunately, it's also pain itself reading Delete Lawz inanity. Hence why I could only get through one of the motions opposing Google's time extension. There were images, not random placeholders, but images of wrists which on cursory inspection appeared to be damaged from handcuffs. The website was published and searchable by search engines, if you can call Bing a search engine. There was no password protecting the website from viewing. Bingo! Hey, one of my predictions came true. No paywall, nor was there any other means of making the website private. There was no disclaimer or notification to site visitors that the site was under construction or in beta testing, because he alpha tests, and that the stories and photos publicly featured on the site were placeholders intended for beta testing of layouts and features. Ms. Peter didn't believe that the stories were intended to be anything other than deliberately manufactured and misleading. Any opinion as to Mr. DeCastro's motives were based on the known facts as stated in the live stream and above in this opposition. Ms. Peter acknowledges that often her public speech contains language that is critical, harsh, expletive-ridden, and at times contentious. None of the speech alleged in Mr. DeCastro's motion amounts to speech that would meet the definition of threatening. None of her speech would meet any statutory definition of harassment. None of the statements Ms. Peter made were illegal under any Massachusetts or federal statute, and Ms. Peter is unaware of any other jurisdiction with power over her speech on YouTube that would apply to her speech and is enforceable in United States federal courts. While Ms. Peter acknowledges that her speech may be perceived by some as otherwise inappropriate behavior, she does not herself consider it to be so and lacks a clear guideline as to what otherwise inappropriate behavior means. That's why court orders need to be clear. They can't be vague. If it means prior restraint on her speech, Ms. Peter would contend that it violates her First Amendment rights to freedom of speech and freedom of the press. And Delete Lawz says he's the best First Amendment auditor. The best. He may be the most aggressive towards cops. He says he's the best First Amendment auditor. He is press. But Kate once again, rules for thee, not for me. The First Amendment is not a protection for Kate. C, standard of review. Mr. DeCastro stated he was seeking criminal contempt in his motion, but then set forth the standard of civil contempt in his memorandum of law. Ms. Peter assumes that Mr. DeCastro intended to allege civil contempt. I allege that he's a moron that doesn't know what the hell he's doing. The elements of civil contempt are well established. To prove civil contempt, a movement must show with clear and convincing evidence. Clear and convincing, that's much higher than preponderance. For the few of you who watched yesterday's video about the Alec Baldwin charges, where I read the probable cause statement, you should all go watch that. I think it's a good one, an interesting one at the very least. We discussed it. There's reasonable articulable suspicion. That's a very low standard. You've got to think, hey, there might be something going on here. Then there's probable cause. That's still below 50% certainty. That's, hey, this is enough at least to arrest you, at least to file charges. Preponderance of the evidence is anything above 50%, more likely than not. That's the standard that this lawsuit ultimately hinges on. Kate is more likely than not to have violated his copyrights. Kate is more likely than not to have defamed him. That's preponderance. The top level is reasonable doubt. No reasonable doubt. That, bear in mind, that's not no doubt at all. It's no reasonable doubts. Like, I could say, well, Alec Baldwin is probably guilty, but I've got to find him innocent. I've got to find him not guilty because, you know, I think an alien could have shot a space laser and been the actual killer. Well, that may be a doubt, but there's nothing reasonable about it. So, no reasonable doubt. Well, clear and convincing is somewhere between preponderance and reasonable doubt. So if you say preponderance is 50%, reasonable doubt is 90%, 95%, 99%, whatever. Clear and convincing is probably 70, 75%. There's no specific, you've got to be this sure, this percent sure. But yeah, so clear and convincing evidence that the alleged contemnor had notice of the order. The order was clear and unambiguous. Clear and unambiguous. Otherwise inappropriate behavior is not clear and unambiguous. The alleged contemnor had the ability to comply with the order, and the alleged contemnor violated the order. See Hawkins versus Department of Health and Human Services from the First Circuit in 2012. While Ms. Peter had knowledge of ECF numbers 33, 43, and 51, the orders are not clear and unambiguous. Ms. Peter assumes that harassment has a legal definition, and presumably the one the court is using is the Massachusetts definition, either civil or criminal, but it's not clear. Same with threatening, where Ms. Peter assumes, but is unsure, that the court is using the federal definition for a true threat, as defined in Virginia versus Black, which comes from the Supreme Court in 2003. And a true threat would be statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. While illegal is clear, otherwise inappropriate behavior could encompass using a salad fork to eat fish at a fancy restaurant. Ooh, it's inappropriate, but it's not worthy of contempt. Therefore, the order is completely unclear. Ms. Peter assumes, based on the court's suggestion, that the parties stipulate to prior restraint. Ms. Peter assumes, based on the court's suggestion that the parties stipulate to prior restraint at the emergency hearing for status conference, that the court did not intend by its order to impose prior restraint on Ms. Peter and prevent her from reporting the news as it pertains to Mr. DeCastro, and or to offer commentary and opinion about those news reports, especially since he refused to agree to that. It was the court suggested, hey, why don't you guys agree to it? She said yes. He said no. Therefore, no prior restraint. Ms. Peter has made every attempt to comply with the order based on her understanding of the order, as augmented by the discussion the court had with Ms. Peter's counsel and Mr. DeCastro at the emergency hearing for status conference. Ms. Peter understood that she was not restrained by the court from discussing Mr. DeCastro's newsworthy exploits and giving commentary and opinion about those exploits. Mr. DeCastro has apparently come to a different conclusion as to the meaning of the court's orders and appears to believe anything Ms. Peter says that Mr. DeCastro doesn't like is harassment. Finally, Mr. DeCastro has failed to allege with any amount of specificity how any of the actions taken by Ms. Peter amount to threatening, harassing, illegal, or otherwise inappropriate behavior that occurred when engaging with each other. Ms. Peter has not attempted to engage with Mr. DeCastro and has only responded to him when he directed questions and comments to Ms. Peter in her live stream's chat. Even when responding to him there, Ms. Peter did not threaten Mr. DeCastro, harass him, engage in illegal activity, or engage in otherwise inappropriate behavior based on the nature and location of the interaction. Conclusion. For the foregoing, Ms. Peter respectfully requests that this court deny Mr. DeCastro's second motion for contempt. Additionally, Ms. Peter respectfully prays that the court clarify its preceding orders for the benefit of the parties. Submitted, Kate Peter, by her attorney, Benjamin J. Wish. So, that's a pretty clear motion. It's, well, response, opposition. Like I said, I would have included Blue Bacon's email, assuming I could get the original from Blue Bacon, which I think he probably would have, even if him and Kate aren't on the best of terms at the moment. Because at some point, stupidity has to hurt. If he continues filing frivolous motions, he's got to pay for Benjamin Wish to oppose them. I would have asked for it to start now, especially with such good evidence that that was his purpose. So we have, though, Exhibit 1, which was included in the filing. And hey, that's from Delete Lawz at deletelawz@gmail.com. CC'd to info@massholereport.com. Ms. Peter, with a penguin emoji for some reason. And this is sent on November 19th, 2022. This is an information request. Additionally, this is an attempt to enter mediation and end this war. Kate, let me be clear. My cousin, who is also a legal scholar, reached out to you in an attempt to amicably resolve the stalking and firing that you caused by stalking me and my friend through your Discord account, caused serious financial and emotional damages to Mr. Zane Kane. The return of Zaner. The information request is that you reveal who the stalkers were/are so that we can pursue them and not you. Kate, every bad person you host will be pursued and dealt with through the court. Mrs. Peter, should you choose to ignore, deflect, or rationalize away this simple information request, it is 100% that you will face a lawsuit this week. I mean, it was already 100% since this was in November. This was 12 days after she filed her answer. TBH, after I learned of the horrible things that you have been doing to people for years and years, your constantly unfair and often unscrupulous dealings with people, I have decided that your misdeeds are worthy of my attention. Therefore, you can and you will reveal to me and my team who stalked Zane at his job in New Hampshire, or I will organize, well, I already have organized, and fund the Arizona lawsuit against you. I mean, for starters, that alleged harassment of Zane Kane in New Hampshire didn't happen. I wholeheartedly believe Delete Lawz made it up. We've seen how he makes up evidence. But let's pretend that it actually happened. How the hell is Kate supposed to know who did it? I mean, she doesn't have to do his detective work for him. If she doesn't know, she doesn't know. He's ridiculous. You have led a poor life, and you have hurt many people whom I have spoken with. Regarding your life, capitalized time, pattern of unscrupulous behavior, it must end, and you must change. We know that change is a slow and difficult process. Therefore, because you exemplify an obtuse and reprehensible life, you must be dealt with through the court system. Therefore, I give you my solemn promise. I will see this through to the very end. You cannot fathom my resolve. We are requesting the names of the people who went to Zane's employer's home in New Hampshire. You have until Monday morning to reveal them, or there will be another lawsuit filed against you. How's that working out? Reveal your trolls or face legal action. This is not a drill, and the clock is ticking. Regards, Jose M. De Castro. P.S. This is the first shoe. Another shoe will drop midweek. I'd wish you luck, but you wouldn't know what to do with it. You wanted my attention. You got it. With another penguin emoji for some reason. Now, bear in mind, Kate is a represented party. You don't send anything to her. You don't communicate with her. The court has ordered you not to communicate with her. I mean, ECF 33. Plaintiff and defendants are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other. Any contact with a represented party should be through their counsel. So, Kate's a represented party. This was not communication through her counsel. This was sent to Kate. And threatening, harassing, illegal. It's definitely not illegal, but threatening and harassing, this is the first shoe. Another will drop midweek. I'm going to sue you. I'm going to have Zane sue you. I'm blah, blah, blah. I'm going to expose you. And then another one. Subject, forward, upcoming litigation in Arizona. To Delete Lawz at gmail.com. FYI is the entire message. Forwarded message from info at Massel Report on the 19th of November. Upcoming litigation in Arizona. Is that what? So that first one didn't have a subject. To Matt DeCastro, who I guess is his legal scholar cousin. Nobody did anything to Zane Kane, this being from Kate. I understand that they fabricated evidence of a made-up incident. This has already been ruled on in New Hampshire as well as Massachusetts, and Arizona has no jurisdiction over me. Don't contact me again. Which was, I assume, responding to this from Max DeCastro. Dear Ms. Peter, Mr. Zane Kane asked me to email you before he filed suit against you next week. He feels uncomfortable contacting you directly. I mean, the way he was trying to intimidate her when he showed up to the, was it, which court was it? One of the Massachusetts courts where he showed up to serve her with this lawsuit. And let's see. There's a senior tax consultant at Deloitte. That's Matthew DeCastro. Crane's Chicago business has a Maddie DeCastro, who's number 37 in the 40 under 40, head of industry, U.S. consumer packaged goods. There's a Twitter account, M. DeCastro, who's an elementary school principal. Several Matt DeCastros on Facebook who no idea. Just quickly scrolling through, I don't see any that I see a visual resemblance. I also don't see any that are legal experts, but either way. Zane plans on naming you in his harassment action with significant monetary damages. The majority of the damages were done by the Kate's Tea Party signs and other vandalism that occurred at his shared residences. He plans on naming you directly and any John Does to be substituted if it comes to light that there were other people responsible. If you are not directly involved and can name the people that are responsible or provide information on them, Mr. King can name those people and leave the John Does for anyone else that the discovery leads to. Please let me know how you wish to proceed by Monday. And then another email from Delete Lawz at gmail.com to info@massholereport.com. Another forward, upcoming litigation in Arizona. Kate, just to clarify, nobody did anything to Zane Kane. I understand that they fabricated evidence of a made-up incident. This has already been ruled on in New Hampshire as well as Massachusetts, and Arizona has no jurisdiction over me, quoting her response to Mr. Matt DeCastro. Let me help you out with your reply to my cousin, and pray you will enter mediation. 1. Yes, you did a lot to Zane. You doxed his residence in Massachusetts, New Hampshire, and Arizona. Where? I haven't seen, at least not in a video, where did she dox anything? I mean, yeah, she exposed his creepy massage RV. Ew. His lotion gun. Ew. 2, nothing has been ruled on because the issue has not been properly litigated. You will not get a Massachusetts restraining order hearing to stop our lawsuit out of Arizona. You, I mean your Arizona lawyer, can submit the Massachusetts restraining order hearing to the Arizona courts. However, the court will not dismiss the lawsuit based on restraining order hearing out of Massachusetts. It will dismiss based on the motion to dismiss for lack of jurisdiction. He still doesn't understand. A court has to have personal jurisdiction. Kate has not done anything in Arizona. In the time she's been covering Delete Lawz, she hasn't been to Arizona. Considering his sovereign citizen tendencies and sovereign citizens, you don't have jurisdiction over me, you don't have jurisdiction over me. He sure seems to think that states where people don't have any contact, haven't availed themselves of any of the state's protections, somehow still have personal jurisdiction over Kate. I don't see how. In what world he thinks Arizona and California can possibly get federal jurisdiction over her. It's ridiculous. It's asinine. Ugh. But 3, Arizona does have jurisdiction because you doxed Zane's Arizona car and father's home address. We have jurisdiction, and we file in the morning. You will have to hire an Arizona law firm. So start looking now. I'd like to avoid paying the $402 filing fee tomorrow to sue you out of Arizona and Cali. 804 for both. I thought this was Zane's Arizona lawsuit. Are you suing by proxy? Do you think you're Peter Thiel versus Gawker funding Hulk Hogan? However, should you choose to ignore this prayer for mediation, I'll file versus you in both states on Monday and Tuesday. This is not a game to me. You have affected the rest of my life in a negative way. I will not tolerate it, and I'll throw my entire being, all quarter of a man of it, into getting justice for the unscrupulous person you are. You can change, and I know you will. However, I'm not waiting for that to happen. You will stipulate, or we will continue in court in 3 states, and I give you my promise to that. Additionally, Kate, I hear you are at $60,000 in legal bills from your criminal case and my federal tort lawsuit. Imagine how much that grows when you have 2 new lawsuits. You messed with a legal scholar who has tons of legal help, yet your writings are absolute horseshit, and you can't follow the rules. You don't know what the rules are. You lean on your pro se status as a crutch, yet you have tons of legal help. I'd rather stop this and move forward with my life, and you can move forward with yours. Zane will file versus you in Arizona, and I'll file another one versus you in California this week. You don't get away with lying and defaming me. Nope, no, you do not. And once again, if he files in California, he's already suing her in Massachusetts. It's asinine. It's absolutely asinine. I mean, remember, I don't know how many filings ago, he tried to use it as an excuse where he said, well, they haven't searched for any collateral cases or whatever they're called. I can't remember. And it's like, but that's what the plaintiff has to do before they file. And that's what the California case would be. They'd look at the Massachusetts case and say, dumbass, you're already suing her in Massachusetts. What the hell are you doing here? Maybe you are enjoying raising money from other people, and that gives you the limelight. I don't understand, to be honest. I'm trying to end this through strength and mediation. I'm willing to stop now and begin mediation. I'd like to move on with my mission, and you can move on to being a better mother to the kids you have left in your home. I can promise you this. My cousin will help Zane all the way through. So your legal scholar cousin, who I notice once again he says legal scholar as opposed to lawyer cousin, attorney cousin, is going to commit the unauthorized practice of law to help Zane in Arizona. Great. I'll move on with what I'm doing next, and Maddie will help Zane until you have to pay up for doxing him, stalking him, and ultimately costing him his job. You have until tomorrow morning to agree to enter into mediation. I'll work with you on Zane's behalf and my own personal interests to stop all lawsuits and move into a peaceful and meaningful mediation. My stipulations are clear. Remove all the videos and my likeness from your page. IDGAF if you apologize or not, so we can skip that. Lastly, enter into private mediation that is not publicized by either of us to compensate me and to compensate Zaner for you and your troll farm, costing him his job. I give you my word, I will not publish or talk about this communication publicly to enter into mediation and settle this out unless you do. I promise you on my life. I just want to end this and move on with my life, and you can do the same. I mean, in what world does he... I mean, compensation. It's laughable. I mean, I don't know what he expects to get from Kate, but she's more or less collection proof, as far as I know. He's not going to get anything from her. But from when he was trolled by Irish Demon, when Irish Demon pretended that he was going to agree to the stipulations. He wanted $50,000 up front and a percentage of all of the channel revenue going forward. He's delusional. Absolutely delusional. And he clearly hates Kate more than he hates Irish Demon. does he really think he's going to get multiple tens of thousands in mediation? I mean, I want whatever this moron is smoking. It's pure delusion. Ugh. And then Exhibit 2 is the Bing search result for end torture cuffs. Post your story on handcuffs. endtorturecuffs.com. We see cops, security, government employees, and others get you put in cuffs for any reason. Most police don't know the laws in this country. Post your story on. With Aaron K. It was on October 2021. It was October 2021. I was headed to a friend's house to play some basketball. I'm only... ... And then videos on end torture cuffs. Forney City Council. End torture cuffs. Resist tyranny with creative expression rooted in truth and love. Oh, truth and love. I thought he was talking masturbation. Truth and love. My mistake. Sheriff torture. I wish this had an indication of what date this search was, but apparently the website that isn't public yet, that Kate had to access through nefarious means, is available, or was at least, on Bing. Once again, Bing is barely a search engine. Who the hell uses Bing? So that's what we have for today. It's 2:22 in the morning as I'm finishing up, and Delete Lawz tends to post very early in the morning. So if he posts anything on the 2nd of February, hey, it's 2:22 on 2/2 of 23. I'm sure numerologists would find something interesting about that. But yeah, so 3 or 4 hours, if he files anything today, that's when it'll be probably. I'm hoping he does, just for my entertainment. So with that, thanks for joining me. I think, obviously, Kate's not in contempt. It's laughable. The judge has got to, at some point, say, cut it out with these frivolous motions. Otherwise, you are going to be sanctioned for them. It's ridiculous. I mean, she's already done the same. Plaintiff in 102, plaintiff is advised that any further motions for leave to amend his complaint will be subject to more exacting scrutiny. I mean, in Merb's video yesterday, even, apparently Delete Lawz is rattling sabers about filing some, I think, Felipe Hemming, or I don't know who the hell that is. And possibly by way of amending him into this lawsuit, once again, I don't know. But as Merb said, Delete Lawz, Earl, as our dear Schrodinger's cat called him, News Now rapist, 2-time now. They're quick to sue, but the only weapon they have in their arsenal is amending the complaint. At some point, the rubber hits the road And you've got to actually litigate. You've got to get through discovery. You've got to actually get through the motions to dismiss. At some point, the court's going to say, you know what? No more amendments. This is what you're suing for. And then they'll dismiss it. And that's the only tool in their arsenal, the only tool in the shed. And it's dull. It's a very dull tool. It's a broken hammer. You're not going to make it through litigation if the only thing you can do to keep the litigation alive is constantly file new, amended complaints. So, I mean, someone jokingly commented on my previous video about Delete Lawz, ooh, you're getting sued next. And it's like, bring it on. I mean, I haven't defamed him. I haven't played any of his videos. I've only commented on the lawsuit, reading court filings. If he sues me, I don't care. It would amuse me. I don't think he realizes I'm out there yet. I mean, I don't watch his videos. I've seen him rage about Merb, but as far as I know, he hasn't raged about me, which I assume means he hasn't seen me. I could be wrong. But it's like I said, I have 80-something subscribers left until I'm monetized. So please, like, share, subscribe, do all the fun YouTube-y stuff. It does help. But if he were to sue me, it could be lucrative for me. So, I mean, like I said, for Blue Bacon's sake, I hope he doesn't sue Blue Bacon. But for my sake, I'm like, oh yeah, hurry, go sue, sue Blue Bacon. Just to give me more easy content. And with Blue Bacon, I believe Blue Bacon owns his house. So he has homeowners insurance. He very well could have his defense covered. At some point, I keep procrastinating. I'm going to make a video, how to protect yourself, specifically as a YouTuber, but it'll still be good for others, especially, small business owners, but also just in general. And insurance is your friend. So, it's if I'm Blue Bacon and I own my house, if Delete Lawz sues me, first person I call is my homeowner's insurance, and say, hey, I've just been sued. You've got a duty, I think you have a duty to defend me. Of course, I'd make sure that my insurance had a duty to defend if this is what I'm doing. But so, yeah, either way, I'm rambling. Thanks for joining me. I will see you real soon, I'm sure. Do all the YouTube-y things, and I'll see you next time. Bye-bye.